Hello and welcome to The Wire. 75 years ago, back in 1950, an important constituent of independent India, the Supreme Court of India, was established in the heart of the country's capital, New Delhi. The country's top court was set up on January 28, 1950. In fact, the first hearing happened on that day, just 2 days after India became a sovereign democratic republic. Year 2025, therefore, is a landmark year for the Supreme Court of India. Many of you may know that we have seen celebrations of this milestone year taking off in 2024 itself, with the Prime Minister releasing in August 2024 a commemorative postage stamp on 75 years of the Supreme Court. Then on September 1st in 2024, we saw the President of India unveiling a new flag and insignia of the apex court to mark the occasion. So that way, today, September 1st, 2025, is the completion of the first year of the new flag and insignia of the Supreme Court. That the country's higher judiciary is touching this milestone makes it also an occasion to look back at the hallowed institution, which is mandated to protect our constitution and the values it espouses, which cumulatively makes us a democratic nation. And I'm glad to share that this is exactly what a book just brought out by Juggernaut has attempted to do. In Complete Justice, the Supreme Court at 75. From the book, from the look of it, you can make out that the book is sizable, divided into 6 parts, comprising essays and interviews of a galaxy of voices. Former judges, lawyers practicing in the Supreme Court, legal scholars, researchers, and also a senior journalist, P. Sainath. So holding the book together as its editor is a respected name from the world of Indian judiciary. Retired Chief Justice of the Orissa High Court as Murlidhar. Justice Murlidhar's editorial interventions in the book, I'm sure, had added a significant heft to it, particularly in choosing what it must include. Also, the significant, the question mark in this title, don't miss that. It is an indicator of what is to be expected. The essays and the interviews concern themselves with a number of significant questions on the functioning of the institution of the Supreme Court of India. And also where its future lies. Everything explained through a slew of appropriate examples so that even a layperson can know the functioning of their top court better. What I understand from my reading of the book thus far is that its remit primarily is within the confines of how the Supreme Court has fared in terms of accountability, transparency, and its responsibility to both the law and the people of India. And additionally, it has also concerned itself with questions like whether the court fulfilled its role as a counter-majoritarian body capable of checking majoritarian impulses and the excesses of state power. And I'm extremely happy to bring to you here Justice Murlidhar himself to discuss the book with me, to throw light on this historic journey of the Supreme Court of India and also his journey in judiciary and in shaping the contours of the book. Welcome to this conversation, Justice Murlidhar.
Thanks, Sangeeta.
Before I get into anything else, I just want to bring your attention to the first line in the introduction, where you talk about the Supreme Court, standing on a triangular plot of land, and it has it's by design. It's
right.
like this, and I didn't know that. So I want you to, if you can just explain a little bit for our audience's understanding, what is the significance of this triangular plot?
See, I basically think since they wanted to shape the building on the scales, and the scales are at an angle. If you hold the scales and it's an angle. So the chamber block and all of that. So if you look at the Supreme Court from above, it's supposed to resemble a balance. This is the explanation given to us. So if you actually have a balance with scales, it will come to a bit of a triangle. So maybe that's how they carved out the plot for the Supreme Court. It's possible. So you really have Tilak Mark on the one side and Mathura Road on the other side, and tapering towards the ITO junction, if you remember.
Absolutely.
And the Bhagwan Das Road here, at the base of it. So, and there used to be a nursery just behind the triangular edge of the plot, which got shifted out. And there was a museum earlier there, and now there's going to be a huge building coming up. Right, yeah. So we've spoken about all that in the introduction. And by the way, this land is leased out to the Supreme Court of India. Supreme Court of India does not own this land. So that's another interesting thing.
Are you implying that it can be taken away anytime?
No, obviously not. Certainly not.
Okay. So there's a lot to discuss about the book, as it covers quite a gamut. Do you say in the introduction that certain subjects you have to keep out because of the paucity of space?
Right.
So, but I want to first focus on the latter half of the introduction, where you talk about certain highs and lows of the Supreme Court.
Correct.
And you very rightly say also that this is perhaps, you say that an objective analysis of the Supreme Court of India would necessitate acknowledging its highs and lows over the last 75 years.
Right.
This is one paradigm that perhaps we can quickly look at and to talk about, look back at the 75 years of Supreme Court.
Correct.
So, and you also say that the attempt here is not to exhaustively list out the instances, but to mention a few critical ones. So these are critical ones.
Correct.
And then we say that 1950 onwards, you almost do a decadal kind of, look back. And 1950, you say that there's an early low, which was the verdict of the Supreme Court, and not striking down as unconstitutional, the Preventive Detention Act 1950. So you say that this is a general consensus, that the first law began in its formative years only. So, is this on this law, the early law, was looking at it's on hindsight, or there was some sort of, opposition to this judgment of the Supreme Court at that time?
See, there was a dissent. In all these cases itself, there is a dissent, which dissent has got resurrected. And like Fazil Ali's powerful dissent in the Gopalan case itself. So very early on, there was a plurality of thought on this. And this was soon after the Constitution was launched.
Yes.
And the Constitution is preceded, the launching of the Constitution is preceded by the debates themselves. So there's a very, very animated debate on preventive detention laws in the Constituent Assembly. And some of them had the foresight to say that, this is going to get misused. And you can actually put away political dissenters. And this is a colonial legacy. And this is what we were fighting throughout independence. Arbitrarily, people involved in the independence movement were getting locked away. And how can we continue this? So there is a lot of scholarship now, although there was not so much scholarship at that point in time. So it is not surprising that you had a dissent very early on. So there was contemporaneous viewpoint that this was a very conservative court and, this was not protecting the liberty of citizens and allowing the executive, because what detention means is you don't involve the judiciary. Preventive detention is executive locking away a person and then producing the person before a board, advisory board, which approves the detention or doesn't approve it. So you bypass the judiciary. And the judiciary was being redundant when it came to the issue of liberty. So one expected judiciary to be very proactive, responding to this habeas corpus demand and saying that, in free India, we can't have arbitrary detentions. And that was why it was disappointing. But the dissent of Fazil Ali has got powerfully resurrected, but much, much later. We are talking of some 67 years later to say these dissents are actually the good law.
Yeah, now we see what that born out of that is like UAPA, TADA, MISA during emergency.
No, and you're talking of substantive criminal laws, with Nitya's talked about extraordinary laws. But I'm talking of preventive detention laws themselves. They've given rise to many other state detention laws. See, for instance, in Tamil Nadu, you have the Gundas Act. And somewhere else I've written, there is a plethora of state laws under which there can be detentions, externment, all without the intervention of a court. And that continues in free India today. So this is something that should concern all of us. And Article 22 of the Constitution actually sanctifies this, which is what is really problematic. Although the first part of Article 22 talks about, being produced before a court and being informed of the grounds of arrest, Sub-Article 4 of Article 22 retains the entire detention law and says legal aid will not, this right to be informed of the grounds of arrest and right to have a lawyer will not be available to a person in preventive detention. This is the Constitution saying it. So we'll have to definitely work still at getting this kind of an executive way of dealing with political questions and to bypass the judiciary. We'll have to again confront this.
Yeah. So this actually is quite strange when you look at the values of the Constitution, the norms of the Constitution, of which liberty is one of the primary poles. So this is something, it's just completely in contrast to. Absolutely. Yeah. So absolutely. This is very interesting. And I see that, when you go through this whole decadal thing, the highs and lows, 1960s is like, I don't find any mention, but 1970s, there are a lot of these mentions that I see. And then when I go through, we'll come to 2000s, but I see that 2000s, a lot of mention of the more lows than the high, like of 1972. So can we compare, these two periods, 2 decades of Indian democracy, or or the Supreme Court's role in the maturing or the journey of the Indian democracy? Like that was a declared emergency. I would call this an undeclared emergency that we are going through in the 2000s, and particularly in the last 10, 11 years. So that was my first thought. Yeah. Correct me if I'm wrong. So I want to ask you these questions. Is it valid? Does it have any premise to look at these 2 decades, place it next to each other, juxtapose them and see certain similarities?
Yes. So I think we come back to a very fundamental premise in the Constitution, which expects the judiciary to be counter-majoritarian. This is how some of us read it. Some of the judges who've come to adorn these benches feel that they should keep, in mind the majoritarian viewpoint, and that they should, whatever they say, and pronounce as decisions, should have validation by a majority of the people. That I, sitting as a judge, have to keep in mind what the dominant voice in society wants me to say. So if as a judge, I have this kind of an attitude, then that will certainly color the way I decide a case. Whereas if I say as a constitutional authority, I'm here to check executive excesses, legislative excesses, administrative excesses, and I say this is the correcting factor. And for a person who's in the minority, it could be a linguistic minority, a religious minority, or a person who has a different point of view, I'm here to protect the constitutional rights of that person. That is what we expect the court to do. So we have these two completely diametrically opposite approaches. And judges who have manifested the first, the counter-majoritarian approach, have all spoken through the dissenting voices. We talk of the great Justice Subbarao, whose powerful dissents have all later on become law. And so this is something that gets played out. So when we have the court, some of us, who believe that this is how a court should be functioning as a counter-majoritarian institution, we believe that the court has not lived up to that expectation. We term that judgment as a low. So it is a subjective point of view, I must admit to that. It's very possible that another scholar might say, no, what you consider to be a low point for me is not a low point. So it all depends on who's viewing the working of the court. But as a person who would expect this institution to be counter-majoritarian, I would term such a decision, which does not protect the liberty of a citizen and permits executive excesses to happen, to be a low point. Like let's take the Kartar Singh case, which upheld Tada, or the Pota case, the BUCL case, which upheld Pota. These are instances where the court should have stepped in and to say, we will not permit this in a law, even if it is to counter terrorism, because it does not serve the purpose and actually it permits the police to act arbitrarily and keep people detained, without trial for long years. So we expected the court to say that, and it didn't happen.
Because we are also a democracy where the right of the individual, even if you're accused of a heinous crime, till proven guilty is extremely important, isn't it?
It is.
That is how we are not a police state.
So that is what, normalizing the exception. That's the title of Nitya's article. Absolutely. Yeah, so that's what has happened over all these years. And countries are learning from each other. The Homeland Security law gets translated as tada and pota here. So, Guantanamo Bay detentions without trial for over 20 years. So, these are bad practices which we should not replicate in our country, but it is happening around the world, including in India. And we expect, there is still hope that the Supreme Court will, call out these excesses and say that we uphold, the constitutional values as inviolable.
You've mentioned quite a few times about Nithya Ramakrishnan's essay in the book, and also next to it is Rebecca John's essay, a fine one on. They both not only talk about these excesses, but also about something which is very important that we expect from the court, which is bail as a law.
Correct.
So, which Rebecca's line is like very, very interesting, I found.
Right.
But in several of these cases in the recent times that we see, I'm like, if you see, say, from the journalistic, arena or from the civil society rights groups, we see that bail is not looked at by Supreme Court as a norm. We are just saying, even if you talk about, say, Siddiq Kapan's case or even Umar Khalid's case, the case is, in several of these cases, what we have seen, is that it gets listed, and suddenly some of them vanish also. Right. And in the process, the years go by. In Umar's case, it's over 5 years. So how do you look at, as someone, what is the view from the other side? Like, I'm a layperson, I'm a journalist. You served in the judiciary. Why is this happening?
See, let me begin by saying one change that I'm perceiving. Because I left practice. I was practicing the Supreme Court for almost 2 decades, then went on to become a judge and have come back to practice. People ask me, what is the big change you're finding? Among the changes I'm finding, one is that a large portion of the court's time, the Supreme Court's time, is today taken up with bails and anticipatory bail applications. And this was not there earlier. I mean, people didn't have to come all the way to the Supreme Court for an anticipatory bail, which is freedom from arrest. And it also explains that somewhere there is a chill factor in the district judiciary. People are unable to get bail orders, even in cases which are punishable with 7 years or less. In fact, I have had, occasions when the Supreme Court judges are exclaiming, for a offense punishable for less than 7 years, do you have to come all the way here to the Supreme Court? That's the harsh truth. There's a chill factor also among the high courts. So when it comes to these extraordinary laws like UAPA, PMLA and all of that, obtaining bail in the first few, phase of the criminal case is almost next to impossible. So if you have the litigating capacity, then you're able to come all the way up to the Supreme Court. But there could be many who don't have that kind of a litigating capacity. So this is a bit unfortunate. And although the judges in the public fora and even in judicial academies constantly say that bail is the norm and jail is the exception, and that's the cartoon. The very first cartoon in this book captures that very wonderfully.
This is the one I want to actually
So when it actually comes down to passing orders in a bail application, you will find there's a tremendous variance. There are a few judges in the Supreme Court who follow this norm and say enough is enough. If the person has already spent, let's say, 3 years, 4 years, and a charge sheet has already been filed, there's no reason to keep such a person back in jail. But there is a complete variation from judge to judge. That also brings me to that very important point about our Indian Supreme Court, is that unlike Supreme Courts elsewhere in the world, they don't sit en banc, which is a French term, ENBANC, which is sitting together. They sit in benches. You'll probably find a few benches in the Bangladesh Supreme Court, but any other Supreme Court in the world, judges will sit together. So since we have 34 judges in the Supreme Court, we have as many as 15, 16 benches at any point in time. It is but natural that, one bench takes a viewpoint different from the other. On the same set of facts, your bench would be different than my bench. And so lawyers practicing the court will immediately tell you, how this bench is going to react to the petition and how that bench is going to react to the petition, which may not be identical. So this is also some kind of a lottery because you don't know which bench your case is going before. So all these factors add to this uncertainties, the delays, and the variation, which is why, although the law is declared, it is departed from every now and then. And this explains why we are at a stage where there's no certainty of all the courts in the Supreme Court, all the benches of the Supreme Court reacting likewise to an application for bail.
This also, I mean, like you talked about this thing, essay. I want to also show this,
Yes.
This is actually
Satish
the
is-
telling times of, it's about, Father Stan Swami dying without being provided, a straw even.
So one of the things about bail, one of the basic things about bail is the person a flight risk, right? Will the person somehow escape, not be, traceable? Stan Swami was 80 years old and he's 82 or 83 years old. Varavara Rao is actually in a severe medical condition. I mean, these are the factors that should tell the court, listen, what are we doing?
Sai Baba case,
Yes.
provided a wheelchair to the person,
So-
which is basic for his mobility.
and what are we trying to demonstrate here? I mean, and why can't we say that we'll hem in with conditions, but why can't we, follow the very rule that we are talking about, that bail is the norm and, jail is the exception. And these people are not some, with a huge criminal history, track record. So these are the things that surprise even a person like me, who's been a lawyer in the law for almost 4 decades. So this is a disturbing trend, that we are allowing detention without trial for 5 years and 6 years, and sometimes without a charge sheet being filed, or a charge sheet being filed, but all the remaining process is not complete. So, and for a fact that after 6 years and 7 years, even if you have not reached the stage of framing of a charge, which is what Rebecca is talking about, then that itself is indication that the trial is not going to come to an end very soon. And there should be no justification for a court to continue to deny bail.
Yeah.
And it's surprising also that the prosecutors, the law officers in the Supreme Court oppose these prayers tooth and nail. So they take it upon themselves to ensure that bail is simply not granted, even if, the detention without trial has been for 7 years or more. I don't know why that is, because they are supposed to be also officers of the court. They see the entire criminal justice system play out before them. They have a good idea what is going to be the time period for this kind of a matter in the long run. They should fairly tell the court, no, this trial is not going to come to an end anytime soon. And we don't need this person in jail any longer. Investigation was over long ago. But we are not having law officers or prosecutors with that kind of an approach. They're no longer objective. They're no longer, assisting the court. They're merely acting as if the government is their client. So this is something that in Meenakshi Arora's interview comes through, that we are not having law officers of a stature who really assist the judicial system in dealing with these kind of pressing issues.
Yeah, this is amazing, because see, normally what we see is that it's just the government that you look at. If it's a government is autocratic, you look at as like processes the punishment,
Exactly.
But if the courts also tend to agree with that, or tend to behave, or at least be seen that way of behaving, even seeing it is also very important in democracy. That if you're seen that way of being, ensuring that processes the punishment, then we have a problem at hand.
Correct. And Sangeeta, Sainath's piece will tell you how uneven it is. Absolutely. You mentioned Kapan. Sainath does the comparison between how the court reacted to Arnab and how it reacted to Kapan. And he's making a point there. He says, some people are able to get the attention of the court immediately, and some people have simply to wait endlessly. And that is something the court should think about. This is the thing about the book. See, how lawyers, former judges view the court is one thing, but how lay persons view it. So that I try to bring together the cartoonists and Sainath. So Sainath tells you what the villagers in Kumair, the victims of the Kumair massacre, what do they think of the court, right? What do they see the Supreme Court as? So this book can help hold a mirror to the court, it would have served a purpose.
No, I'm sure. This is a person, and for me, this is like a mine of information.
Correct.
To form an idea about Supreme Court at
Right.
age 75.
Right.
Where have we come thus far?
Correct.
And also you talk about the future of it.
Correct.
At this point, I would like to take you back to the lows and the highs
Hmm.
and to 1970.
Mhm.
This particular case of 78 verdict in a Maneka Gandhi
Hmm.
case,
Hmm.
where the Supreme Court talks about the need for due process.
Right.
So this is something that you do want to talk a little bit about, that the due process is so important.
So I think this is also political. I think we should see this going parallel with the political history.
Correct.
Maneka Gandhi happens at the end of an emergency period. Right? So post-emergency, we see the birth of public interest litigation. We also see the court having to reaffirm its role in protecting life and liberty. So Professor Bakshi brings it out very well. I keep asking him, do you see this period of atonement? And he agrees with, he agrees with me that this was the period of atonement, the two champions of liberty being Krishnayar and Bhagwati in the forefront. And, they saw what had happened during the emergency. They saw that this had a strong disapproval of a majority of the Indian people, which is why they voted Mrs. Gandhi out of power and brought in the Janata government, and how that government collapsed. So all these political, events were played out in front of the Supreme Court. And they were somewhere responding to that need, that the court was not really there earlier, responding to the needs of the people, and now they felt that should happen, which is how that whole due process clause, which the constitution framers were advised to keep out of the constitution, was read into the constitution by reading together as a scheme articles 14, 19 and 21. I don't want to get into the technicalities, but this was a watershed moment in Indian judicial history.
So it was an atonement for not striking the emergency proclamation?
Also not protecting. You see, what happened in the emergency, the people's right to approach the court was taken away.
Taken away, yes.
And the Supreme Court, by a majority of 4:1, said yes, that is perfectly valid. So, and that included the senior Chandrachud, Justice Bhagwati. It was only Justice Khanna, if you remember, who dissented. That's right. So that was 1976. And, Edim Jabalpur. And now you have the launch of the PIL frontally with this Charles Sobraj, Sunil Batra, Husainara Khatun. That whole launch of that happens towards 77, 78. And that's how that new era began. And Maneka Gandhi happens in end 77. So
such an important case,
Yes.
Another low, when we come to the 1980s, you talk, of course, talk about the Bhopal gas tragedy judgment, which was not in support of the victims. When we look back, even now, you also mentioned about the 2023 thing, how the curative petition failed.
Yes.
So, but another thing in 1980s, which you look at as a low point, was the first judge's case, in which the Supreme Court is in a way given into the power of the executive to appoint judges.
Correct.
Until date,
Correct.
we have not been able to sort out this issue.
No.
I saw Justice Madan Lokur's very interesting, incisive piece as an insider on how the collegium works, not just the Supreme Court, High Court. We have not been able to sort this out. What is your personal view also on this,
See, first of all, and Justice Madan Lokur points out that simply saying India is the only country where judges appoint judges is not true at all. Judges have not been able to appoint themselves. At least in the last 10 years, we've seen that the executive does have almost the last word. And if you go into both Justice Shah's and Justice Lokur's pieces, you will understand that the so-called collegium system is not working well enough. But both of them voice concern that unless you find another system that can take care of all the mistakes of the pre-collegium and the collegium system, don't simply keep substituting it with another, right? The experiment with the NJAC, I feel, on paper it might look good. You have 3 senior judges of the Supreme Court, you have a Attorney General and let's say a law minister or a nominee of the Prime Minister. We don't know if all of them will act independently, because there are so many factors at play, like the post-retirement offerings, which both of them talk about. Justice Shah talks about, Justice Lokur talks about, and others have also mentioned this. So these are all worrying factors. How much ever precaution you might take to show that, to insulate institutions and individuals from external influences if they don't wield the power in the way it's supposed to be wielded, that system will fail. So it hinges upon the individuals occupying these positions at various points in time who will assert the independence of the judiciary and do what is expected of them. That's why you find some Chief Justices of India, even if they have a short tenure, they surprise you by the kind of independent decisions they're able to take and assert themselves. And some who have longish tenures disappoint you very deeply that nothing really happened to reassert the independence of the judiciary during a period of, let's say, even 3 years or 2 years plus or whatever. So individual to individual, I'm finding that it matters.
Yeah, so important, I as a, for a layperson, if you look at layperson, Supreme Court is looked at as one entity, which is like not changeable, but it depends on who leads the Supreme Court.
Exactly.
I mean, that's what we have seen in the 75 years journey when we look back, through the book. That is what we are getting to see.
I'll just give you one example. And this we never anticipated. It was a very pleasant surprise when Justice Sanjeev Khanna was the Chief Justice. He decided to put on the net that entire processes, the granular steps in the selection of judges for the high courts and even the Supreme Court. In fact, even a flow chart you have. You have the detailed memorandum of procedure and even the forms that are sent for being filled up. Justice Khanna simply said, this all should be in the public domain. Everybody should know what are we looking at when we are looking at candidates for judgeship. This is very surprising. And you had an earlier phase where detailed resolutions were put up by the collegium on, why they were choosing certain candidates. All that changed. So suddenly they decided, no, we'll only give what are called statements. So one Chief Justice of India says we should move towards transparency. The other says, no, let's roll it back. Let's not give reasons. So this opacity in the functioning of the court is actually become counterproductive. People then misunderstand what the court is about and then mistake also that the entire Supreme Court is one entity, which invariably it is not.
It's not, yeah. So I'll just go back to the 1990s and then you talk about one high point, which is that S.R. Bomai case, where they said you cannot do the casual use of Article 356 of the Constitution by which a governor can bring a state, under precedence rule. And mostly that was happening in the opposition rule state. And we're getting to see that also now, like Manipur precedence rule is quite an aberration. People were talking about it and finally it had to do it. The government had to do it. It had no other option, but it was, I sometimes really think, having come from the Northeast myself, that would it have happened had it been an opposition ruled state? Mm-hmm. Because here the lives and property and everything was at stake, Mm-hmm. So then S.R. Bomai case you mentioned is the high point in 1993. But then you say that the high point was preceded by a low point in December 1992 when the Supreme Court failed to pass orders to prevent the congregation of the Kar Sevaks, in Ayodhya, and then it happened the demolition of the Babri Masjid on December 6th. And then after that, we see what a whole lot of developments leading to CJI, Ranjan Gogoi's time, granting the land. And that is a judgment a lot of people, even within the civil society, questions. So history will, of course, view at this as how it does. How do you see this 1993 for me? As I was going through the highs and the lows, after 1970, 1990s became the big volatile period of Indian nation because, through these judgments, what I'm beginning to see is that it's very crystal clear that how the journey, the trajectory of India as a nation can also be seen through the Supreme Court judgments.
Very true. Very true. Also, if you remember, the liberalization phase was in the 90s.
Yes.
And, the way they responded to that through the PILs, they kept throwing out PILs which questioned disinvestment and privatization, saying that this is all a matter of policy. And when it had a direct impact on the lives of people, then, that was given very little attention. If you see the closure of the polluting industries in Delhi, there was a whole factor of displacement of workers in all those factories. And that was not really, thought of. So it's very interesting what you say that the 90s judgments mirror the contemporaneous events of that time and also the attitudes of judges. So if you the way you choose the judges also matters. If you're really concerned about plurality on the bench, you should not keep out certain points of view only because they're not acceptable. If the person is very good at what the person does, which is study the law, analyze the law, apply the law, and believe in law as an instrument to achieve justice, to render justice, we can't keep those persons away because their political inclinations may be different. But that is happening. You will find that certain points of view that judges might hold make them disqualified, ineligible to be considered for being appointed. So this is that appointment process of judges, particularly to the constitutional courts, does matter, and this book demonstrates that. So 90s is absolutely, you're right, that it reflects those changing events. Also, I think politically, 90s was a coalition era. And you can see that you have a strong judiciary when it's a coalition era, and a relatively weak judiciary when it's when there's a dominant government with an absolutely a majority in parliament. And both of them, I think Justice Shah, Justice Lokur, and other writers have also commented on this.
Very, very interesting. And then when we come to the 2000s, of course, you talked about the progressive verdict of the Delhi High Court, which I think you were part of it in the Naz Foundation case, where reading down of the Article 377.
Section 377.
Section 377 IPC. And and then it was challenged and so many things happened, but 2000s, a lot of those cases. And of course, the case, Puttaswamy case and all of this. But I want to quickly come down to the 2018s and all that, because the lack of time, I just want to quickly come to that about CJI Deepak Mishra's time, when there was a big hangama, about he being the CJI, being the head of the roster, who decides which case will go where, which bench and all that. And then when we see throughout the book also in Mr. Panchu's, I think, interview, the senior advocate Panchu's interview by you, we see that he actually makes a case. He says that Sriram Panchu's, that it should not happen to it. It is actually not. It actually should not happen, because to keep the objectivity in mind. Will you just throw a little light on what his argument was, and what do you think personally?
See, the CJI as an entity is fairly powerful. Although he's supposed to be, co-equal with all the judges on the judicial side. Like, for instance, it's a 3-judge bench which the CJI is presiding. It does not mean that he can't be overruled by his 2 colleagues. So, as a judge, the CJI has no different power than any other judge of the Supreme Court. But on the administrative side, he's like a first among equals. So he or she does wield a power which is far greater than all the other judges of the Supreme Court. That power, whenever we talk of power in the Constitution, there has to be check on that power. There has to be accountability. And it has to be able to be reviewed. So it has to be able to be questioned. But there are also what are called silences in the Constitution. The expectation in the Constitution, and we talk of all these high constitutional offices, whether it's the President, the Governor, the CJI, the expectation, if you read the constitutional debates, is we would have such persons who need not be told how they should behave. They would obviously know what is right, what is wrong, what is arbitrary, what is not. There would be people of such stature. But it has been a point of a disappointment. That over the years we find partisanship among all these heads of state, governors and all of that. And even CJIs have not been entirely above board. The book tells you all those instances. So this master of the roster, Panchu feels, is a power which needs some kind of a check. So he says, just like in the appointment of judges, they brought about a collegium system, a plurality. Even on decisions of how to fix the roster, it should not be left just to the CJ of a high court or the CJI of the Supreme Court. I may not entirely agree with him, because in practical terms, it becomes difficult on a daily basis when you have to fix rosters to have this extensive consultations. But it is important, and I have done it as a Chief Justice myself, to have informal consultations with your senior colleagues. That's important. Take them into confidence and tell them, are we doing the right thing? What is the general impression we're getting? What's the feedback we're getting from the lawyers? They'll be the first ones to give you feedback, saying, mounting arrears in this one particular bench. they're not able to dispose of for a variety of reasons. Then you say, let's shift those cases to some different bench. And the lawyers might say, this one bench does not give any relief at all, even in a deserving case. So these kind of feedback I have got as a Chief Justice, and I'm sure the CJI gets on a daily basis, not just about his own colleagues, but about even the high courts, different benches. This is something that is always floating in the air. So we must be responsive to that and take the senior colleagues into confidence, in which case there'll be no room for the kind of press conference that happened. Yes, the famous January press conference during Justice Mishra's tenure as CJI. So that showed that there was a breakdown of communication between him and his senior colleagues. We can't rigidify this process. We can't lay down rules on master of the roster. The expectation is, if you look at the past practices and how there have been CJIs who have been admirably wielding this power without too much misgivings from the colleagues, there is a way, there's a scope for what I would call course correction. And yeah.
And one other thing I quickly want.
There I must say that the way you constitute constitution benches, there's a tendency for some CJIs to say, let me preside over every constitution bench. And that also has misgivings, because there are senior colleagues with you. You will say, okay, this time I'll preside over the constitution bench. Next time, the second senior most, third senior most, they will preside over. And then there'll be a rotation, because when you become a Supreme Court judge, one of the things that you expect to do is to participate in that development of the law, laying down law. It's a big thing, and you get to speak your mind, because these are very matters of great importance. And if you're kept out of those constitution benches, then there's a heartburn, there's misgiving and all of that. So this is also watched very closely by all of us as lawyers and law persons when we see the composition of the constitution benches. And I really think there's a need to democratize that practice as well. And all of that again hinges back to this question of master of the roster.
Yes.
How responsibly you wield that power. That matters. So
is there any other example in other courts, in different other?
Yeah, because they sit en banc, this problem doesn't arise. Like in the US Supreme Court today, let's say there's a bail application. Justice John Roberts doesn't have to break his head in saying, before which bench should I list this bail application, right? Whereas the CJI today, actually, he can determine who will hear this bail application. So you will find that immediately relief is given when some bench hears it, and then relief is denied when some other bench hears it. And then who decides which bench will hear it? The CJI. So it's a very important power, and it needs to be, critiqued. The best way to make sure that there is no arbitrariness there is to constantly critique it.
Yeah, I think that's what the book has done, not just in this aspect, but so many other aspects related to the Supreme Court. The occasion is also, the 75 years of the institution. So I want to quickly come to, also about the pending cases.
Correct.
When Supreme Court started its first hearing on 28th of January 1950,
Correct.
they had around 690 pending cases, you mentioned, in 1950, and now to over 81,735 pending cases as of May 31st, 2025. How does one tackle this problem?
So merely having more judges is not the answer. So you'll have non-lawyers give you reports, write op-eds saying it's a no-brainer. You just need to double the judges, triple the number of judges. But that's not the only solution, because if you get judges who are not efficient in disposal of cases, then merely having more judges is not going to solve the problem. So Justice Ravindra Bhatt's chapter is very important on trying to understand what constitutes arrears, what constitutes pendency, and how to develop what is called a life cycle of a certain case, and get to see the best performance for that kind of case, the worst performance, form a median, and fix norms, saying that are you above the norm or below the norm in disposal of cases. And every judge should do that. So we have reams and reams written on case management, court management, and all of that. But at the end of the day, if the judge is not interested or unable to use that kind of information to improve one's own functioning, then there is a problem there. And there's a problem at the level of the Supreme Court, the High Courts, and the District Courts, that a few judges have the scientific approach to say, let me see how I can clear my board, right? So much depends on the judges themselves. We do have judicial academies where they're given lectures, but I think we need to engage with this more seriously. And Ravindra Bhatt also makes the point about the functions that the judge is expected to perform in the Indian judicial system, not just deciding cases. They all go into the chambers after a full day's sitting. They barely have time even for a cup of tea. They're called away to a committee meeting. There are administrative committees on all levels of the judiciary. So judges are racking their brains on, which tender to accept, which vehicle to buy for the staff, which uniform should we approve for the staff, whose vigilance inquiry should we order, how do we write the annual confidential roles, the performance evaluation. So it's a plethora of functions that judges are performing outside their judicial functions. And they're not actually trained for this. They learn on the job. So that also occupies a lot of their time. And then we expect them to deliver judgments on time and efficiently, giving full reasons. So if you read Ravindra Bhatt's chapter, you'll see where the impracticality sets in. And he makes a strong case for an administrative service adjunct to the judicial service, where professionals come in and take over some of these tasks, whether it's infrastructure, whether it's personnel management, whether it's financial management. Judges are having to approve budgets for the court's expenditure. They're having to, understand balance sheets, flows of money, and sometimes they have to call the secretaries, the finance secretaries, or other bureaucrats from the government. Sometimes the chief secretary to say, "You're not sanctioning this expenditure for this court." And we've gone ahead and announced the building of so many courts, and what about the money for it? So these things happen on a regular basis at all levels. So like service of warrants, right? We don't realize this. If the superintendent of police of a district does not cooperate, the criminal justice system of that district will collapse. You're so dependent on police for service of warrants and summons to the witnesses, capture of the criminals who have jumped bail. So much of this, work of the judge is not strictly confined to what happens in the court, but outside the court as well.
Yeah, how beautifully you have put this, how we are so dependent on each other, and the executive too, judicial dependent. So at this point, I want to also quickly ask your opinion about, there's something that we've been seeing now with this whole controversy around the CEC appointment or appointment of the Election Commission of India, and where the CJI was part of it and then being kept out. Now it's the executive that is deciding who's going to hold the elections to elect them. So it's like where is the CJI? And then we don't see the court, the office of the CJI or anything. We don't see Supreme Court asserting itself there. Why do you see this is happening?
See, this is something called the will of the people. So even now it will be argued that where the constitution is silent, right now the presidential reference that's being, the advisory opinion that the president has sought on the powers of the governor.
Correct.
Clearing bills presented to them by the state legislatures. There is a tendency to say that stay off. There are clearly defined, demarcated areas. Judiciary should not step into the domain of the executive or the domain of the legislature. And, this is judicial aggrandizement, not judicial activism, where you're usurping to yourself powers that you don't have. This is a constant criticism. So in trying to meet that criticism, some of them pull back. Some of the courts, some of the judges pull back and say, let's not go that far. Let's not dictate, what kind of a law there should be. But there comes a time when nobody does anything. Like, look at the criminals in politics issue, right? So it had to be the Supreme Court which stepped in to say, you better have an affidavit disclosing the involvement in criminal cases and your wealth. That disclosure came through a judgment of the Supreme Court. Of course, there was an ordinance which was again challenged to the Supreme Court. Fortunately, that bench continued. So it's about continuity as well. Now, the bench which gave this judgment on the CEC is not the bench which is considering the validity of that law.
Yes.
The players have changed. So they may have a different point of view. They may say, oh, this is what the parliament wants. So let's not, try and stay a law made by parliament. Let's consider it quickly. But that quickly has no meaning. If you look at Usha's chapter on judicial delay and pragmatism, there is no explanation why certain issues will be put on the back burner. Like demonetization decided so many years later. Electoral bonds is decided so many years later. And to no real effect. Electoral bonds, we were all delighted that the court had struck it down. And then you read the smaller print that, nobody's got to return monies.
Yeah.
So, it completely neutralizes whatever effect it might have had as a deterrent in future for these political parties to take funds in secret without any formal disclosure to the public. So this, from court to court, judge to judge differs, comes back to that first point that we said, master of the roster, and keeping certain points of view away from a bench. That plurality of opinion, how you constitute benches, and how you respond to the need to be a counter-majoritarian institution. It all comes to that.
Yeah, it's amazing. So I would like now, I'm like towards the end of the interview. So I want to come to your chapter.
Yeah.
You talk about the digitization
Correct.
Where we see that the COVID-19 effect of COVID-19 on the Supreme Court was actually supreme, in terms of digitizing it. They had to really roll down things quickly. And as the Chief Justice of the Orissa High Court also, you had also put in a lot of effort there, to digitize and all that. How important is digitization now? And of course, there is no going back to, from hearing cases online. So what is that paradigm shift that has happened, or is it for good?
No, so let me start with how a court appears to any person visiting the court. If you walk into the Tizari court, or let's take even a court in Ghaziabad or Sonipat, you'll find that there is paper everywhere, right? Yeah. Very soon the court's corridors are filled with cupboards, stacked with papers. Inside the court, you look around, you'll find files everywhere. So it's paper. Even when we sit down to plan the court infrastructure, we immediately talk about, record rooms, where are we going to store the files? So we have paper in mind.
It's quite intimidating for a common person.
And paper is destructible. So when you had a flood in the river Jhelum, if you remember in Srinagar, I'm talking about a decade ago, records of the High Court were lost because it was all paper, it got soaked, could not be retrieved. So there is a real danger of so much paper occupying in the Delhi High Court, when you have walked around the corridors in what we call the branches, you will find that even the toilets have been converted into storerooms for paper and staircases are full of paper. So one thing that digitization does is to free up space and make the record more permanent, readable and usable. But you have to follow certain protocols, which if you do, it's as good as preserving the original record. So one direct benefit of digitization is freeing up infrastructurally, freeing up space for the court. Also, if I come into a workspace and, as let's say a dealing assistant in a court, and I'm standing and working because my chair is full of paper, the floor is full of paper, cupboards are all and shelves are full of paper, it depresses me to walk into that kind of. Whereas if I have a paper-free atmosphere, it helps a lot. So today that is possible and it's demonstrably much better. But we need a supporting infrastructure in terms of, best equipment, servers, latest technology and technical personnel. So if we try and do this ourselves as a judiciary, we are not likely to succeed. We've been dependent all the time on what is called the National Informatics Center, which serves all departments of government, and they're stretched. So it was high time that the judiciary had for itself an exclusive agency, which is under its control, to undertake and oversee this whole, exercise of digitization, of bookmarking the files, of providing technical assistance to judges, train the judges in use of paperless courts, conduct proceedings, in virtual mode. All this is possible. In Orissa, we did it in 2 district courts as a pilot, where the trial could be held in virtual mode without excluding the possibility of physical witness. Somebody wants to be physically present, they can of course be present. Somebody insists on physical presence of a witness of cross-examination, certainly that can happen. But there are a large number of witnesses who are what are called formal witnesses, official witnesses, who have just to prove that they carried a paper from one place to the other, or they received a complaint, something such like that. So they need not travel all the way to the court, wait there. So we gave time slots. The trial judges in Orissa actually gave time slots to those witnesses. Trial speeded up without anyone having to move from anywhere. So those experiments were then replicated in other districts in Orissa. So if we put our minds to it, it is a doable thing, but we must learn to delegate. We must learn to prioritize. What I'm finding is if one Chief Justice of India shows interest in digitization, in live streaming, in online hearings, another says, no, I don't want to do anything like that. So this inconsistency in the approach might retard this process of digitization. That's as far as the infrastructure is concerned. I think what we also need to pay attention is the security and privacy of data, confidentiality of data. And I don't think we've got enough protocols for that. So there is a danger that if we don't build in all these protocols, this digital data may get either misused or corrupted. So I speak about that as well.
Absolutely.
I don't think there's a way of going back. This can't be rolled back because as a society, we've moved into a digital era. And with kind of protections and protocols in place, we should be able to use this digitization for the best benefit of the judiciary. It's a doable thing. I think we have to put our heads to it. We have to get the best in the business for this. And there's no lack of funds. I think if people think we don't have enough money for this, they're mistaken. Many courts are unable to utilize the funds that are given to them. And I can't blame the judges. They're not trained for these kind of things. If I'm faced with a bill of 500 crores, I get, kind of put off saying, am I doing the right thing? Maybe I should not take this decision. But you leave it to professionals. They'll tell you what should be done and what should be avoided.
Yeah, so that again brings back us to this question of, about the need for a judicial administrative service.
Correct.
Yeah, that's true. And you mentioned also in your, very informative chapter also about the first ever paperless court in the High Court was like
in
the Delhi High Court, which is
so Justice Bhatt was the first, mine was the second.
2009, yeah. So, and from there it's 2025, we're still talking about it,
And my hope in Orissa also was this. Let's start with the younger judges. Judges who come into the first level of the judiciary. And they will be very happy to hold paperless courts. Let's start there. They'll be less reluctant to go into the paperless mode. And they're all fairly comfortable with digital devices. And we can train them. And whichever the court they move to, that court will become a paperless court. And if we start right from the bottom and then travel up, maybe in 10 years' time, we can have a completely paperless judiciary. That's the expectation.
Let's hope by the time, Supreme Court turns 100, we have all these questions sorted out. So I just come to the complete fag end of the interview where you do an interview of Sri Ram Panchu.
Right.
They talk about the Supreme Court in the next 25 years.
Correct,
Okay.
correct.
So he talks about a lot of these things, judicial delays and the appointment of the judges and so many things that needs to be addressed. And in court administration,
right.
and also the need for judicial education, training, etc. So if I have to pose that question to you, like the Supreme Court in the next 25 years, in your words, where do you want to see this hallowed institution at age 100?
I want it to be far more independent, far more assertive. I want the bar. And we didn't talk about the bar enough.
Yes.
The bar has lost its independence over the times. It's got dominated by certain elements, and we are not having a democratic functioning of the bar. The way the elections are held at the level of the bar associations, the bar councils, leave much to be desired. And there's very little critiquing of how the bar functions. There's a kind of a discussion with Meenakshi Arora on that in the last few chapters. But we need to have a far more active debate on what the bar really stands for. If you don't have an independent bar, we will not have an independent judiciary. The bar must make that demand for an independent judiciary. When judges are attacked or judges are punished for being, asserting their independence, the bar must stand up. They do that, but selectively. So, and having said that, I must say that there is a younger lot of lawyers today who hold out a lot of promise. They are far more articulate, they are far more confident, they have better exposure. They've been to, the best law schools in the country. They've also done a bit of their education abroad. They've worked with judges, either as interns or law researchers, and they're able to pursue causes, and they're doing it out of an idealism and out of a commitment. And they're working on very difficult cases. Just to give you an example of Project 39A, which is now Square Circle, those young lawyers have farmed out into all the trial courts, visited prisons, unearthed stories of injustice, litigated that, and got justice for the people. So it's remarkable to see this young lot of lawyers doing so well. So that is also giving me hope that in the next 25 years, if this lot of lawyers, become senior, they become the bar council and the bar associations, they demand a certain degree of independence, not only for the bar, but for the judiciary, we'll be in a much better place as the Supreme Court of India.
Yeah. Thanks for pointing out that Supreme Court is not just comprises of only judges. There's so much else. There are also lawyers,
and the law officers.
See,
we want to see those additional solicitor generals or attorney generals not merely act as lawyers for a client. In the whole design of this judiciary and at the level of the highest court, the Supreme Court of India, these were all called officers of the court. So we need to bring up that standard again. I'm not taking names at all because this decline has started quite some time ago. It's not in the recent past. This decline started more than 20, 25 or maybe 30 years ago. But we have to course correct. We need to bring back, that level of the bar, which can, work together with the judges in elevating the standards and the independence of this institution.
So it's absolutely, I'm glad that you pointed this out. I was reading this essay by Gopal Subramaniam in this book. It was such a pleasure to read about these luminaries that used to argue at the Supreme Court, and over the decades. This is amazing. And also you talk about Meenakshi Arora's...
and also Indira's. Indira
Jaising.
Yeah, so she's a lawyer who started appearing from the early 70s. She's watched 50 years of, several generations of judges. So that comes across in her interview. Remarkable insights into the working of the court and such courage, taking on issues, standing for causes. And it's not easy. It's still very much a male-dominated bar. And she is kind of a torchbearer then, for several generations of women lawyers. Today, I'm happy to say, whether you look at the Delhi High Court or the Bombay High Court, some of the major metropolises, and even the Supreme Court, women lawyers are doing wonderfully well. There used to be a time, like Meenakshi talks about that, will it be typecast? Family law matters will go to the women lawyers. Meenakshi and Indira and all of them, Nitya, Vrinda, Rebecca, they're all there as, examples of very competent professionals, top of their field. So it's a very happy development that's happened. And that trend is continuing happily in the Supreme Court, where women lawyers are doing extremely well. And
yeah, I'm glad you actually pointed out the gender that plays, has a role in this 75.
And we should go beyond that, right? We should look at, sexual minorities, trans people. They must come into the bar, into the judiciary, people with differently abled people, all of them. I'm saying that plurality is all around us now, emerging slowly, but in good time, it should make our bar more diverse, our courts more diverse, and the institution itself far more democratic.
Yeah, absolutely. And I just hope by the time we turn, like the Supreme Court turns 100, we at least have a woman's Chief Justice of India, which is...
Justice Nagaratna will be the first woman Chief Justice of India, but she's given hardly a month. Yeah. So this again, all this, it will take up a lot of time. The first two essays discuss that. We call the succession plan. Like today, we know if Justice Pancholi's appointment goes through, he will be the Chief Justice of India in the early 30s. We already know that. So this is again the power of the Chief Justice of India and the present day collegium to decide what will happen even, let's say, 8-9 years hence.
Yeah. It's amazing. Thank you so much for this lovely conversation, and it was such an eye-opener for people like me, we are laypersons. And do take a look at this in Complete Justice, the Supreme Court at 75. Not to miss the question mark, because a lot depends on, because this is on this question mark that there's so many questions of these hallowed institution being asked.
You have a minute. So just to explain where that incomplete justice comes from, Article 142 of the Constitution says in order to do complete justice, the Supreme Court can pass orders which is out of the ordinary. And, that power has been wielded so often by the Supreme Court, and the court thinks it is doing complete justice. But the question is, has it actually done complete justice?
Absolutely. On this note, we end this conversation, and thank you so much for watching this interview and for supporting and engaging with independent media. Thank you.